Good morning, and thank you for being here. We are teaching the updates to the joint Dayton and Cincinnati contract. As you all may know, we have had a joint contract for over a decade now with Cincinnati. We love this, what I'll call Southwest Ohio contract. We think it really is the best in the marketplace. It has been so thoroughly and thoughtfully considered and prepared by the forms committees and the joint committee. And last year when the NAR settlement came down, we each handled the commission and compensation negotiations a little differently. And in doing so, we had a divergence of the joint contract. They immediately incorporated it in the contract. We in Dayton made it an addendum so that we could see how we wanted to tweak that over the coming year. Now those tweaks have occurred. We've both jointly agreed to them, and they're included here today. And so we're really thrilled to be back to a joint contract with Cincinnati. And so thank you, and we will get started right away. Hopefully you have the contract in front of you. And if you haven't had a class with me before, what I will say is that if you have to take a call, if you have to run to the restroom, if you need to hop up for any reason, you're not going to bother me. Just come and go as you need to, and we'll keep rolling through this. We otherwise don't take any official breaks throughout the duration of the class today. The first change that you're going to see as you get into the contract is a very simple and straightforward change. We previously had a blank where you could negotiate the number of days for the buyer to provide proof to the seller that they had delivered the earnest money either to their broker or to whatever a third party was identified, often a title company. And if they did not identify a number of days or negotiate a number of days, then it would default to 3 days. I will say the state, the Division of Commerce, the Division of Real Estate and the Department of Commerce does want this to be a reasonable period of time, but what is reasonable for your transaction may differ. For example, you might be working with someone who is right here local and can hand you a check right away. You might be working with someone who is across the country or across the world at the time that they enter into the contract. You might be going into a holiday weekend like we've got coming up. And so all of these things can impact what's reasonable for your transaction, but do input a negotiated number of days. There is no default, and there is no question that is more frustrating for an attorney like myself than what do we do if we didn't say anything? Is that 0 days? Is that up until the end of the contract? I don't know. It depends on who I represent. It depends on many other factors in the transaction, so please don't make that an ambiguity. Please specifically negotiate that. One thing that I will reiterate is that always make sure your clients well understand the terms and conditions of earnest money hold. In no circumstance under this contract does the earnest money automatically return to a party. That is specifically delineated within the contract. And it is very important that your parties understand that. Sometimes a contingency will fail, or one party will believe that the contingency has failed, but there is a dispute over whether that earnest money should or should not go back. Perhaps the parties have become aggravated with one another for other reasons, and a party won't agree to it being returned. But the earnest money will not automatically return to a party in any circumstance under this contract, unless it's 2 years past and it's held by a broker, or perhaps your third-party escrow holder, your title company, is holding it under those same terms that an Ohio broker is bound to. But 2 years after the contract, it would automatically go back to the depositor only at that point in time. That can be very frustrating news to a seller who feels that they are entitled to the earnest money, or to a buyer that thinks that they should rightfully have it returned because a contingency failed. The appraisal contingency, the base language of this section did not change. We previously stated that you could negotiate the number of days if it was privately financed or a cash transaction. You could negotiate the number of days for the appraisal contingency, but if it was a financed a property by an institutional lender as identified within the contract, that it would be the time frame set forth in section 4. Now we've clarified that that is section 4D. There's many timelines in section 4, so we didn't mean to create an ambiguity there. So it is clear now that it is what is detailed in section 4D, which for reference I've shown here, no changes there, which is the date that you've agreed for the clear to close. So whatever time frame you all have agreed for final loan approval, which is the clear to close date, shall be the date that appraisal contingency expires for institutional financing. Inclusions and exclusions. Let me say it now. Let me say it many times, early and often. What you advertise in the MLS or otherwise does not dictate the final terms of the buyer and seller agreement. Your contract dictates the final agreement between the buyer and seller. It's very obvious with regard to price, right? Maybe the seller listed it for $500,000 and the parties had a bidding war and it went for $510,000. Maybe the seller listed it for $500,000 and the buyer came in and negotiated $490,000. Nobody ever thinks, well, we put in the MLS it was $500, it's going to be that no matter what. But for some reason, people think that with regard to what is included or excluded from the property. Any fixtures, and the good way to understand a fixture is if you could pick up that house or condo or whatever type of property and turn it upside down and shake it, what would fall out? If it would fall out, it's not a fixed. It's not a fixture. If it would stick to the property, it will automatically convey unless excluded, unless specifically excluded. We have a laundry list of things that are not often fixtures that are automatically included in our base contract. And now it includes hot tubs and equipment. Some people want the seller's hot tub. They are thrilled that this is in there. Some people don't want the seller's hot tub. You will want to strike it or else the seller is required to leave it. There's a section 2 where you can specifically identify other things to be excluded. I would say if you're specifically identifying them, it would be smart practice if it's duplicated above to also cross it off there. But definitely detail or reflect that you are crossing something off if the seller doesn't mean to include it or if the buyer doesn't mean to include it. Is it equipment that pertains to hot tub? Yes, and that's a grammatical interpretation based on the placement inside the commas. So yes, thank you. All right, section 7, compensation. For Cincinnati, this was already in their contract over the past year, though it has dramatically reworded and changed. I think you all will see that it's very similar to a lot of the wording that was in the Dayton contract, but it's not identical. But this section for the Dayton folks, so folks who have continued to use the Dayton version of the contract, this entire section is a new insertion. So it is now section 7. Anything after that has just bumped down a section. We didn't add any other new sections to the contract, but what used to be 7 is now 8, and so on and so forth. So you'll see it, lines 128 to 130. And I will add, we've previously had a Zoom class, and we hadn't been through final editing on the contract at that point. And as we went through final editing and kind of formatting and making sure that things looked pretty on the contract, it tweaked some lines. We didn't meaningfully change content. It was just more of an editing and formatting change. So what you have here is now the final version that is presently available for use. You will want to stop using the prior version of the contract and use only this version going forward. So lines 128 to 130, this capitalized section is the conspicuous language that is required under the NAR settlement, but also with regard to Ohio law when it comes to compensation, that they are broker fees and commissions are not set by law, fully negotiable, and may be paid by the buyer, the seller, the landlord, the tenant, or a third party, or by sharing or splitting the fees and commissions between brokers. The next section that is bolded is that nothing in this section shall amend or supersede compensation due to any brokerage under any other representation or compensation agreements. And also, if any blanks in the below section, anything negotiated between buyer and seller are left, if anything's left blank, it shall be construed as 0 or not applicable. So first of all, with regard to it not superseding, if a buyer is in a buyer representation agreement with their own agent and they have agreed to pay their own agent, I'm going to say 3%. And it is important that I always say, when I use actual numbers or percentages in these presentations, it is for exemplification purposes only. It is not to suggest that these are the commissions that are usual or normal or required. But let's say that there's a buyer compensation agreement, buyer broker agreement, and the buyers agreed to pay their own agent 3%. And in the terms of the agreement that you're going to see that follow, I'll go ahead and advance. In the terms of the agreement, that's one more 3, sorry. The seller only agrees to pay 2%. It doesn't change what the buyer's already under agreement to pay their own agent. They still owe their agent 3%. It now, if negotiated, has been offset by the seller's contribution of 2%, so the buyer would owe that difference. You'll see that specifically delineated here. Similarly, let's say that in the listing agreement, the seller representation agreement, the seller was making a certain offer of compensation to a buyer's agent, and the buyer's agent negotiates something different. What's in the contract prevails, but it doesn't change how that offering would look in that listing agreement in a go-forward basis if this property, or excuse me, if this transaction would not complete and they would put it back on the market. So the next area, the buyer's going to identify who they are represented by, what brokerage, and specifically what agent, or they're going to identify that they are self-represented. So if you are a listing agent and a buyer represents themselves and you are completing this contract on behalf of your seller to present to the buyer for signature, a little bit in reverse of how it usually works, you would select that the buyer is self-represented and therefore, presumably, that there is no compensation agreement agreed to be paid by the seller on behalf of a buyer's agent. But if there is going to be an agreement, the buyer can identify who they're represented by, and then as we go forward, they can then negotiate and have the seller agree to pay a dollar amount and a percentage amount. Maybe that seller is going to pay $1 and a percentage. Maybe that dollar amount is a transaction fee, and the percentage is some or all of what the buyer broker was already entitled to receive under their own buyer broker agreement. If either one of those is left blank, it will be construed as 0. I like for you to put a dash or a 0, but if it is left blank, it is construed as 0. It goes on in little section 2, so C2, to say buyer shall pay all remaining buyer brokerage fees, if any, due from the buyer under the buyer representation agreement, i.e. buyer brokerage fees due under the buyer representation agreement, less amounts agreed to be paid by the seller, if any. So back to my example, buyer broker agreement says 3%. If seller's agreeing to pay 3% here, it zeroes out. Buyer's not left with anything. But if seller agrees to pay something less than that, the buyer is responsible to pay the difference unless they and their own broker would specifically agree to amend that agreement otherwise. Other terms for payment of compensation, maybe there's going to be an offer for the buyer to pay something on behalf of the seller's agent. Maybe that's the case even in a self-represented buyer. Maybe it's a competing bid situation where the buyer doesn't want to inch up the price anymore because it's just not going to appraise. I can put this price through the moon, but it's not going to appraise and I'm getting financing. So maybe the way that I make my deal a little more attractive to the seller is that I agree to pay some compensation to their broker. And you could insert that or other unique terms into these blank lines. Long day again. I'm on hour 3 of teaching this morning. All right. Notwithstanding the foregoing, it does say that if for any reason the parties would negotiate that the seller should pay something more than is entitled under the buyer-broker agreement, that can't happen. That is set by the NAR settlement. You cannot negotiate for any party to pay more to your buyer-broker than you have already agreed to pay your buyer-broker under separate representation agreement. Said differently, you, if you represent the buyer, can only get paid what your representation agreement says you can get paid. So if you happen to know that a specific property or seller, whether it's a builder or a private seller, is offering a bonus or something more, you want to amend that agreement, at least with respect to that property, before you tour that property or write an offer, whichever shall come first. Tour the property is consistent with the NAR settlement. Write the offer is consistent with Ohio law. So you need to go to the sooner of those two things to comply with both. So you cannot negotiate for someone to pay more. I've had many circumstances where sellers have agreed to pay X percent to the buyer's agent for the seller to only find out that the buyer's agent was entitled per their broker agreement to nothing or to 1%, and they had agreed to pay more than 1%. So do not negotiate for more than your buyer has already agreed to pay you as the buyer representative. And for clarity, lines 162 to 166, we're just going on to say that unless otherwise agreed, sellers still paying their own representative, their own broker, the fees due under the representation agreement as agreed. All right, let me stop there for a second. Any questions in this section or something prior? Yes. All right, senior moment. I have senior moments, so I embrace those wholeheartedly. We're going to come back to your question. Write it down if you think of it, and we'll come back to it. Thanks, Bob. I'll own your senior moment. I have plenty of my own. One more won't matter. Any other questions right now? Yes. Yeah, so the question is, and I'll repeat questions so everyone can hear and know what we're answering. So the question is, all right, in these examples again, let's pretend that you have a buyer-broker agreement that you're entitled to 3%, and you negotiate, or your client negotiates with the seller for them to pay 2.5%. So we've got that 0.5% difference there that the buyer would be required to pay. But you as the buyer-broker say, that's okay, I'm going to agree on this transaction to take less. You would then go back to your buyer-broker agreement and amend it to go down to that 2.5%, or to equal what the seller was paying that is less than what you were otherwise entitled to. You can do whatever you want, but I will encourage you that you would utilize the addendum to your buyer-broker agreement that is transactionally specific, that it will be just for this one specific property. This is a contract for 123 Main Street, and so we're just going to amend my compensation agreement as to 123 Main Street. So if this deal falls apart in inspections or some other circumstance, we're back to my normal agreement because maybe it works out differently on the next deal. So you don't want to amend that globally unless you really want to amend that globally. Yeah. Oh, Bob's got it. We're back. Yes. What do you got, Bob? Question is, if the buyer representation agreement is 3%, the seller in the negotiation only agrees to 1%, and the buyer says, well, sorry, agent, I'm not going to pay that difference. You're not required to change what you're entitled to. You can say, well, it sounds like you don't have a deal then with this buyer or with this seller, because you would be in this transaction now required to pay me the difference. Or if you say, that's okay, this is literally our first property, or whatever other circumstance you have, that you say, that's okay, I'll take just the 1%, or just whatever it ends up being. You would then go back to your buyer representation agreement and amend it. Again, I would suggest on a property specific basis, though you could amend it globally, but why would you do that in case this deal doesn't happen? So hopefully that answers. Yes, we've got one more question over there. Do you have to amend it? Your broker may want that. I mean, most brokerages are auditing in the end. Like, this said you were entitled to such and such amount, and you only received that amount at closing. Where's the difference? So for that reason, you may want to. If nobody's going to ever dispute it, you wouldn't need to. I like clean paperwork like that, where all those dots are connected and everybody's clear. Your client starts to understand, too, that amending it is an essential part of you aligning those two agreements, because otherwise they are responsible for the difference in the middle. But if you didn't amend it and nobody's disputing your brokerage and you are not disputing that you're entitled to that difference, legally there's never a problem unless there's a problem. So that wouldn't be a problem. All right, let's take a couple questions here, and then I'm going to move on and maybe take questions at the end. Yes? The seller has offered, in this scenario, in this question, 3%. So when they put the listing together, they agreed to pay their own agent a certain amount, and they, in the listing agreement, said, go ahead and offer 3% by way of this example. And yet, when the buyer broker came along, they were only entitled to 2%. If that buyer broker had not changed their compensation agreement prior to touring or writing the offer, whichever came first, if they had not changed their agreement, either globally or with regard to that specific listing and property, then the buyer's agent can only negotiate for up to the amount that they are entitled to under their own representation agreement, which in this example is 2%. So that extra percent would not be paid by the seller. Depending on how that listing agreement read, it might stay with their listing agent if that amount was coming out of the listing agent's compensation at a higher amount, or if it was offered in addition to what they were otherwise paying their agent, it might just mean that the seller keeps more money in their pocket. But they would not pay it to the buyer's agent, and again, that's reiterated here in the terms of the contract, to support what is already understood under the settlement, which is you cannot take more than or negotiate for more than you are already entitled to receive as a buyer representative. Yes? So the question is, and this is jumping back to the earnest money, so just taking 2 steps back to our first slide there. When can that earnest money be returned to the party who paid it or distributed out of the transaction? If a broker is holding it, they are bound by Ohio statute on a broker hold, which is the earnest money can be applied to the transaction at closing, credit to the buyer at closing. But if the closing's not occurring, then what? It can be distributed in accordance with mutual written agreement, not unilateral demand, but mutual written agreement, or court order, or after 2 years, automatically returned to the person who deposited it, or persons or entity that deposited the funds. Now, if a third party is holding it, not a broker, it depends on the terms of that escrow agreement. Many of those escrow agreements, our company, for example, align with Ohio broker law in that regard. But it would then depend on the terms of that third party hold. Okay, I'm going to move along for now, and we'll have time for questions. I'll stay around at the end as well. All right, seller certifications. The seller certification section, by and large, has not changed. What you see here are just 3 areas that were reworded. We thought they read better. We liked it better. So they've just been reworded to does not, has not, or has not had. So it was amended for the rewording, not that it changed the type of certification that was being made. I will also add, as a practice note, I strongly encourage you to have your seller review all of these certifications prior to the listing, and put somewhere in your MLS or otherwise, give the buyer the right answers. Here's what my seller is in fact willing to certify. My seller has had time to thoughtfully review these. Do not skip over this section. My seller has had time to review these, is making these certifications, and I'm putting it out there so any offer coming in, you can get all the right answers out of the gate, which isn't to say that the seller shouldn't pay close attention. The seller should pay close attention to each and every answer, each and every offer, to make sure that they have gotten it right, that the buyer has filled out these certifications to their best of understanding and the best of their knowledge, and that, yes, they are in fact accurate. So please always review the seller certifications very carefully with your clients. Association throughout the document, throughout the entire contract, wherever we said homeowners association, condo association, HOA, we have now changed it just to association. It's just the same reference regardless of the type of association, and just for consistency, ease, and clarity. There are some associations where at the time of purchase, the buyer will owe an initial capital contribution to the association. Historically, this was often done for the very first buyer of a newly built home. So that developer or that newly formed association would say, hey, we got to get some seed money in here. And so just the first buyers, the first-time buyers, we're going to have to pay a one-time capital contribution fee in addition to any ongoing dues or other fees or assessments that might become payable. It is now more common that sometimes subsequent owners also have to pay an initial capital contribution fee. So at the time that they close, that new buyer also owes that capital contribution fee. So this now provides the disclosure or opportunity for that to be included in the contract. So here you're going to say on line 209, the association does or does not require a capital contribution fee to be paid by the buyer at closing in the amount of such and such. Again, a good thing to discuss with your seller up front so that they can have that in their marketing materials or agent remarks or something available to the buyer or buyer's agent so that they can get this right when they write the offer. Or to the extent that the seller doesn't know, I'd encourage a seller to find out what other fees might be due at sale or transfer that they're going to be responsible for in advance of listing their property. I would encourage them to find out, are they going to owe a capital contribution fee, or is a new buyer, I should say, going to owe a capital contribution fee as well? But if they haven't done that and they don't know, like, well, I had to pay one, but I don't know if the next person does, or I just don't remember, it's been so long, or who knows? They can mark unknown and move on, but it does become then something for the buyer to figure out during the disapproval period. So that's a due diligence item then for that buyer. Seller can also certify, we already had in there what the regular association fees were, whether those are monthly, quarterly, or annually, or some other periodic amount or time frame. But now we have a secondary association area. So really common, I think a Settlers Walk's a really good example, where they have two associations. The master association that applies to every property within there, and that operates under one set of rules and requirements and fee structure and due structure. And then they have the sub-associations, the secondary associations, depending on what part of the community you might live in. Those are different fees depending on the amenities of that different area. So there's a lot of associations structured in that similar way, and so now it provides that you can disclose both of those on the contract. Associations, if you all don't know, many of them are managed, professionally managed, and the fees for the status letters that are required at the time of closing, the fees for transfer to a new owner, new account setup fee, they call them a million different things. Those are all the seller's responsibility under the terms of this contract. That's not changed, but they've gone through the roof. They're really high. I mean, they're several $100s in many cases now, $300, $400, $500. It's not uncommon for us to see that. And they charge an extra rush fee if we don't order that status letter and that information at least so many days prior to closing. For some associations, it's 5 days, some it's 10, some it's 15 or more days. So that's why we've now changed it. It used to say 14 days because that's what it tended to be on the long end before. It's now, if the seller doesn't provide that information to the title company at least 20 days prior to closing, seller's responsible for any rush fees that their management company or their association might charge. If you are one of the realtors that doesn't timely return or at all return those realtor information sheets to your agents, I beg of you, please do that. We need that information, but most importantly, don't wait till you have everything related to the transaction. Get this over to the title company right away so that at the very least they can order that quickly and reduce the fees that are due by your seller at the time of closing. Yeah, quick question. So the question is, if it is selected for the initial capital contribution, let me go back a second, if it's selected unknown, subject to buyer's verification, disapproval within the disapproval period, and so yes, that's a contingency, and you can specifically delineate if you want to add language around if it's more than, in your example, if it's more than such and such amount. If the initial capital contribution is more than, fill in the blank, such and such amount, buyer has a right to terminate. Maybe put time frame on it. All of those add-in contingencies and language. Make sure that they're just very clear and as to what is required to trigger the contingency or to satisfy it. All right, maintenance. So later in the contract, as has been there, no change, it states that the seller, when they turn occupancy over to the buyer, whether that's at closing or sometime later as agreed, the seller has to remove any and all personal belongings that haven't been required to stay at the property, and any and all debris. So the seller's, that's still in there. Seller is required to remove their stuff and their trash. have them get rid of their things. But we're trying to make it abundantly clear that unless otherwise agreed, so unless you write in somewhere else in this contract that the seller has to have it professionally cleaned, have the carpets cleaned, have the whole kitchen wiped down and sanitized. And we love sellers like that, by the way. Yay for those people. But we don't want buyers to have a false expectation that unless otherwise agreed, seller shall leave the real property in broom swept condition. So again, they still are required to remove their personal debris and belongings that are not contractually required to stay, and then otherwise just leave it in broom swept condition, which is not a high threshold of cleaning. It is not deep clean, sanitized, which can be gross to some buyers, but they should expect that, and yay for the sellers that don't leave that. And what happens when they don't do it is the question. I mean, as with anything in this contract, when a seller doesn't do it, buyer has remedy. Whether it's worth it to the buyer to pursue that legally or otherwise is up to that buyer. I always caution realtors, you take such good care of your clients, and you want to absorb their frustrations and their pursuits of making sure everything is done. But once it's post-closing, it does become a legal matter. So I would really limit your involvement to a reasonable level if you want to direct a communication. But if they want to pursue this otherwise, it's not for you to reach legal settlement or to pursue these folks legally. A lot of this type of stuff, if they didn't leave it in broom swept condition, it's got, and again, broom swept condition, very low threshold, but they leave all sorts of trash and debris, and they've got to pay a junk hauler hundreds of dollars to come in and clear it out. They could pursue that legally if they wanted to, and a lot of those amounts would be under the small claims threshold where they could pursue it. Property survey, so that buyer still has a right to obtain a survey. Their lender may require a survey, and as has always, or for some time been in this contract, this contingency is not intended to limit what the lender might later require. But if the buyer wants the option to get out of the transaction and to terminate because the survey results are not as anticipated, the buyer has to have the survey completed as detailed in section 15. And we hadn't previously clarified that we meant 15A, which for cross-reference is below. No changes to that 15A, but we're talking about their inspection period. So whatever time frame you decide for their inspection period, that initial inspection period where inspections are going to occur, that's the same time frame they have to complete their survey, if that's a contingency to get out of the contract. Insurance verification contingency. This previously just simply defaulted to 14 days. Now they can negotiate the number of days that they want for their insurance verification contingency. What we've also added here is something that was done in response to individuals, and often individuals who were coached by their realtors to misuse the insurance verification contingency. The insurance verification contingency has always been intended for a buyer to be able to exit the transaction within the time frame agreed, previously predetermined, now as determined by the parties. Don't leave it blank, that's ambiguous. Insert something there. But for the buyer to be able to say, look, I can't get insurance, I need to be out of this transaction. If it's a finance transaction, that would trigger the financing contingency anyway. But also to allow the buyer to get out if the insurance cost was inconsistent with market rates. Some subjectivity there, naturally, but it can occur where for this size property in this type of an area and this age of a home and whatever standard factors there are around the property, you can get several insurance agents, and most lenders know the standards for insurance more or less, to say, okay, that insurance for that property should probably run about $1,000 a year. Well, if that specific property has had multiple claims on it through no fault to the buyer, maybe no fault to the seller, that insurance could be substantially more. Instead of $1,000, it's rolling in at $1,800 or more. So it's intended for circumstances like that, where it's so out of the ballpark, this buyer really isn't comfortable with proceeding. Again, that's the kind of thing that might still trigger a financing contingency and lead to disapproval of the loan anyway. But now we require proof. So if you're trying to use this to get out, because what was happening is that clients were terminating the contract based on the insurance contingency, insurance verification, but it was really because they had inspections and they didn't want it anymore. Or another property came on the market that they wanted more, and so they just wanted to flip out of this transaction onto another one. And so this didn't require any hard proof, and so they would send this over, and in the cases where it was litigated, they found out pretty much in every circumstance the buyers hadn't even tried to get insurance. They were just using it because they knew there was no proof required. And in those cases as well, it often was revealed that their realtor had suggested they do that. I'm glad to say it doesn't tend to happen too much up in our Dayton market, but it was happening in other areas. So it's just to keep everybody above board as to what it's really intended for. Title insurance contingency. So there weren't major changes to this section, but it was all reworded just for greater clarity. We thought it was due for just a reword. So let me just take a minute to make reference to that first paragraph. Again, we're notifying the consumer the title insurance is available, that a lender's policy of title insurance does not protect them, and that we encourage them to contact their title insurer or their settlement agent to discuss the benefits. What we have added is an indication that both a standard owner's policy of title insurance and an enhanced homeowner's policy of title insurance are both available. They're not always available to every single buyer. The enhanced policy is not available on land only. It is only available on 1 and 4 family residents, so it's not available on multi-unit. And it's only available if they purchase the property individually or as trustees of their own trust. So if they are buying a property in an LLC, that enhanced policy is not available. But the Columbus contract defaults to the enhanced policy now. And I'm just going to refer to it as enhanced. Under the American Land Title Association standards, it's officially called a homeowner's policy with a capital H, which is what we've sort of redundantly said, the enhanced homeowner's policy. I think that's confusing. It makes it sound like your homeowner's insurance. It has nothing to do with your windstorm fire liability insurance. It's your title insurance. So this enhanced policy is available for most buyers of a residential property. and the Columbus contract defaults to it. There's many differences, but I will say briefly, it's been around for over 25 years now. It has become very, very popular within the last few years, and it's a reason that Columbus now defaults to it because of the amount of fraud out there. It is the only type of policy that protects the insured against future fraud. So somebody falsely conveying their property, somebody falsely taking a mortgage on their property. It covers a lot of other things too. It's got some inflationary coverages, can cover them in the circumstance of improvements that didn't have proper permits pulled. It provides a lot of good extra coverages, but the fraud is really the main thing that's made it notable. So most title companies are wanting to give the client the highest and best coverage, and the client can always elect for something else, but they should be talking to their title insurer about it. And if you have questions, do talk to your title company about that. So the question is, should you recommend your buyer talk to their insurance company? You mean regular insurance, their homeowners insurance? It's not. And that's why it's confusing. No, they won't talk to whoever's providing their fire, windstorm, that type of coverage, the liability coverage. They'll talk to the title insurance agent. You have to be a licensed title insurance agent, and I don't know of any who are also carrying those other multiple lines of other types of insurance. So then what has changed here with regard to the selections? You still have kind of the same basic selections, but it's been reworded a little bit. So first of all, buyer can elect to purchase their owner's policy of title insurance at their own expense, meaning they're paying the full cost. Buyer shall later determine. So we had previously buyer elects not to. What was happening is the buyer, if they would elect not to and then not purchase it at the time of closing and then have something that was a title claim, they would point a finger at their realtor and say, well, they just marked that. They told me to mark that. And so now you have a dispute and a legal matter between them and we don't want a circumstance where it appears that you've told them not to. Please don't tell your clients not to. Don't give them that advice. It only creates liability and risk for you. If anything, have them pick that they'll later determine and have them talk to the title insurance company. Next options, seller shall pay the amount of $500. So I should have highlighted this. I just missed that. It previously said $300 towards the purchase of an owner's policy. So when $300 was originally established as an amount that the seller could contribute towards this without taking on the full expense, the $300 at that point in time was the difference between a lender's policy and an owner's policy on an average purchase transaction. Needless to say, in our market, prices have gone up substantially in the 20 years since that occurred. So it's bumped to 500. It could really probably bump a little higher, but it was decided to bump it to 500 at this point in time. And then the last option is that the seller will pay the entire cost of a standard owner's policy. So again, we're trying to delineate because a lot of title companies, a lot of people are defaulting to or selecting an enhanced policy of title insurance. And so it now says seller will pay the standard policy, the whole thing. Buyer, though, you're responsible for the simultaneous issue fee that would then be due for your lender's policy if one is required. And if you are obtaining, so it says if applicable, additional premium for the enhanced homeowner's policy. And again, just to kind of emphasize why this distinction has been introduced into this version, not only because we do have this now in the statewide contract, we also have it as a default in the Columbus contract, but Montgomery County, which is where we're located, is now so bad that they have a special fraud unit at the recorder's office in reviewing deeds. The Montgomery County Prosecutor's Office has a specific fraud task force, and they are regularly enforcing criminal penalties against people. So it is abundant. Title insurance underwriters will tell you that it is the number one current claim or cause of claim and anticipated to be the number one cause of claim over the next many years. So something to take very seriously. Quick question, yes? So the question is, did I say, and yes I did, that that title insurance covers against improvements that weren't permitted? An enhanced policy. And again, I will say it's always subject to the terms and conditions of an insurance policy. My underwriters would cancel me if I didn't make that clear. But a buyer can't take on a known risk. So a buyer can't take on certain risks and then make a claim for it, just like a buyer couldn't buy a house that had flames coming through the roof and then try to make a claim on their homeowner's insurance. But yes, that's an additional coverage covering unpermitted improvements and under the enhanced policy. And there's again, there's many more additional coverages that are certain encroachments if they elect to also get the survey coverage. I mean, there's a lot of additional coverages that can be available there. It isn't a much better policy. It's a great policy. And then down below the next section, 422 to 427, this was previously in there, but just to reiterate, seller's agreement to pay any portion, all of, or some of the premium on behalf of the buyer for a title insurance policy is only applicable if the buyer elects to buy it at closing. Sometimes buyers will defer and buy it after closing, and that's their prerogative. But it does not, you can't later go back on your seller post-closing and go, hey, remember you agreed to pay $500. I need that now because now I'm getting it. It only applies if they buy that policy at the time of closing, so that we don't have them trying to go back on the seller later. All right, conveyance and closing. So this is simply, this section, obviously you detail when you're going to close and what title company. Here, I always recommend that you put the title company and their phone number. Back to fraud. Wire fraud is awful, and we send wiring instructions in an encrypted platform. Hopefully your title companies are doing the same. But we still say, please don't skip the step to take 2 minutes, literally, if that, and call us and just re-verify what you've gotten from the encrypted platform. It's your last line of defense to make sure you're wiring your money to the right location. In Ohio, we are a good funds law. Every amount over over $10,000 must be wired to the title company or settlement provider. So they are wiring funds, and there are so many scams out there to get them to wire their funds to the wrong place. And it happens with an alarming frequency in our marketplace. I could spend another hour just telling you stories of that happening in multiple transactions in our marketplace. And if you, in every case, the client did not take the time to call the title company and verify. Give them the phone number for the right title company so that they know where to call to verify wiring instructions, to get other information that is pertinent to their transaction. But then we've added a sentence because this section also details, again, and there's a lot of redundancy with other sections, what fees buyers are responsible for, sellers are responsible for, and we've reiterated that the buyer shall now be responsible for any initial capital contribution fee to an association. The agency disclosure. So always important. We've now detailed also that it has become an integral part of this contractual document. We want the buyers to have been properly disclosed on the agency, but we also want the buyers to acknowledge that it's an integral part because they're making representations that they don't have any other representation. And so we don't want disputes to arise related to who's entitled to what compensation. And so that agency disclosure is critical, and it is reflective of who is representing each party in the transaction. The sole contract, so we've always had in there that, we can have facsimile or other electronic signatures. We've kind of brought it up to, we're 25 years in, and we're bringing it up to this century to say electronic transmissions are acceptable just for ease and efficiency there. Indemnity. So indemnity sections, this section is actually longer, but these provisions right here have been added to it, back to the representation, and back to it being an integral part, and back to Section 7, now the negotiated compensation. Unfortunately, something that we are seeing is that many buyers are now signing multiple representation agreements. They are not reading them. They are not understanding the terms, conditions, the scope of the agreement. Or they do understand that, and they get a little bit annoyed with their realtor, and they decide they like somebody else a little better. Or they think they can just ditch that person who has spent multiple days and hours, left family events to go show them properties on the drop of a hat. Not that that ever happens, right? So they decided that they want to just ignore that person and now work through another person. And they put an offer in with another realtor. And sooner or later, their original agent that they're still under agreement finds out, and a dispute arises related to the broker compensation. We're making it abundantly clear here that that dispute is between the broker and their own client. When that comes up, it ends up being a problem at the time of settlement. Oftentimes that original broker will make a demand with the settlement agent that it go on the settlement statement. It becomes a thorn in the side of the transaction. It is the liability of the person who has breached their original agreement, which in my example is the buyer. So it says if any other party, if any representations turn out to be incorrect with regard to representation, that person who has misrepresented the representation, it is their responsibility, their liability to indemnify and hold harmless all the other parties of the transaction. Basically, it's not going to be the seller's problem. It's not going to be the other brokerage's problem. It's going to be theirs to resolve, and they're going to make sure that no other party suffers a loss or damage as a result of that. Buyer certifications. Guys, when you begin to work with a buyer or seller, there's all sorts of preliminary homework you ought to do with regard to the property you're listing, with regard to making sure you've got the right owners and that they have the authority to enter into the agreement. But whether a buyer or a seller, one question you should always ask, if it is individually owned or will be individually purchased and financed, is, are you married? Very simple question. And if they've got somebody next to them and really they love each other, clearly, don't assume that's their spouse. Please ask, are you married and is this your spouse? Who are the owners? Are the owners married? What are the spouses' names? In Ohio, it's relevant. We are a dower state. We are one of 3 states in the entire United States that still have dower laws. Yes. And so because of that, a buyer cannot buy and finance. A cash buyer can, because they're not financing and no spouse has to sign off on a mortgage. But a buyer cannot buy without their spouse's consent. Too many times we get to days before closing, or literally the day of or day before closing, when the documentation is prepared, and all of a sudden we realize the buyer's married. And their agent goes, what are you talking about? I've never heard about their spouse. Their spouse has been nowhere to be found. Or they go, yeah, sure, they're married. It's Susie. Susie's not their spouse. It's Ann. It's whoever. That's not their. So if they're going through a divorce, they should take action earlier in the transaction to address how they could take title where dower would not be relevant. Doesn't mean that other marital property issues may not apply. They should probably consult legal counsel, but they should address that issue very early on. So we are having them here identify any and all parties that are not buyers under the contract that would be necessary to complete the contract. That's usually going to be a spouse, but it could also be if mom and dad are co-signing. So if mom and dad are co-signing for the loan, you would also identify mom and dad because they're essential parties to this transaction and they're not part of the contract. A seller should know this, and it brings awareness to a risk level to a seller. It might change their willingness to accept this offer. What do you mean there's another spouse that's required? Are they happily married? Is this spouse along? Yeah, they're just doing it for their own personal reasons. Fine. But no, it's an ugly divorce. Or they've agreed for now that he or she will probably sign off. Boy, that's a little risky. Or there's no problem, but spouse is on mission trip in the middle of nowhere or deployed, and they forgot about a power of attorney. So these are these are moments to ask some additional questions. It's not something to leave blank unless it does not apply, and then you should have them write in none so that they're affirmatively representing that. But have that question. As a realtor, don't be blindsided by the fact that your client is in fact married. And that language, by the way, is already in there with regard to the seller. We just thought we should add it for the buyer as well. At the end of the contract, we've had in there for some time that all owners and spouses of owners must sign. We added now closing documents. As I will reiterate per what I just finished saying, buyers' spouses must also sign certain financing documents, most notably the mortgage, if it's not a cash transaction. All right, guys.